Okay, so let me call it real quick. This is in the matter of the people of the state of Michigan versus Jonathan Jeffords. We have two files, file number 2018-19058FH and file number 21-20628FH. I have Dawn Van Duzen appearing on behalf of Mr. Jeffords, and I have Christopher Fleming appearing on behalf of the people. So I'm going to open up a million breakout rooms because I know we're going to need them. And Miss Van Duzen, I'm going to change the screen name of Mr. Jeffords so I don't lose him. And I will put you and Mr. Jeffords into a breakout room. Where are you? There you are. All right, we'll open that breakout room. Okay. So, Mr. Jeffords, you might need to use the mouse to click on
to properly defend the client.
Have you requested through discovery the documents from whoever else is necessary? I don't know. Signal and defense training. Okay. What is your name?
Sure. Oh, me, Ronald Wood.
Wood? All right, Mr. Murphy. Let's see, you probably have today, Miss Van Duzen today, right? Okay, so when we're done with Mr. Jeffords, we'll take care of you, okay? So you can go on your way. All right, I have. Yeah.
Mr. Jeffords?
Yes.
Real quick, you're going to plead guilty to the violation of probation. I just talked to the judge, and at sentencing, she'll just charge you from your probation with Mr. Jones.
Got it.
Okay.
Thank you.
Yep.
Now, quick question. The charge that the charge that I'm pleading to, will it go down as, it won't go down as
It's just a misdemeanor.
Okay. Okay, cool.
Mm-hmm.
Cute.
Thank you.
All right.
Could impede his adjudicative capacities. Mr. Jeffords refused to discuss psycholegal concepts, including plea options, key courtroom personnel, court procedures, or potential legal strategies. However, the absence of an impeding mental condition, recurrent exposure to the legal system, estimated cognitive functioning, and prior forensic examination suggest he has capacity to understand and apply psycholegal constructs. The data further suggests he has a recent history of understanding and applying legal constructs via rational decision-making, Thus, the aggregate data suggests he has the capacity to comport his conduct, rationally assist his attorney, and make rational legal decisions if and when he chooses. The collateral data warrants concern about appropriate behavior during legal proceedings. However, there is no substantive clinical data suggesting he lacks the capacity to comport. Therefore, it is this evaluator's opinion Mr. Jeffords did not have a mental condition impeding his capacity to understand the nature and object of the proceedings against him, or to rationally assist in his defense during the forensic interview. The undersigned respects the ultimate decision in this matter depends on a judicial determination, though it is this examiner's opinion that Mr. Jeffords is competent to proceed with his legal case. And then there is, a one-page document dated December 21 of 22 that states that Mr. Jeffords refused to complete the forensic interview as intended, and they're unable to offer an opinion within the bounds of reasonable medical certainty without active or appropriate participation, and signed by the same J. Knighton, PhD, licensed psychologist, consulting forensic. I just handed that to Sue so she can see what I read from. All right, so the court will make the finding that he is competent to stand trial. Ms. Adams, I do show we have no fingerprints, but he's in the jail. So I'm assuming they can get that done. Ms. Van Dusen, on file number 22-20628FH, what will he be pleading to on that file?
It'd be MDOP 200 to 1,000. With,
so it'll be an added count 2.
Yep.
MDOP 200 to 1,000, which carries a 1-year maximum penalty.
With a killabrew to no further jail.
No further upfront jail?
No further jail, correct, Your Honor.
Okay, so at the time of sentencing, he'll be released?
Upfront. I thought he would be released today, Your Honor.
Mr. Fleming?
That's fine, Judge.
Okay, so we'll give him a PR bond today on that file. All right, and then on the violation of probation, I'll arraign him on that. So, Mr. Jeffords, let me get back to the front of my script. So, can you raise your right hand for me, Mr. Jeffords? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes,
Do you understand that?
I understand.
All right. Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you FH? So, Mr. Jeffords, would you agree that on August 25th of 2021, you were in the city of Adrian in the county of Lenawee?
Yes.
And at that time, did you damage a vehicle that belonged to someone with the initials MS?
Yes.
Okay, what did you do with it? Did you kick it? Did you punch it? What did you do to the car to hurt it?
Yeah, I'm not really totally sure. Contrary to the report, I do have mental issues, so yeah.
I understand that. Would Ms. Van Dusen, do you wish to ask him a question?
Yes, did you pick up a statute and throw it at the car?
I honestly, I wouldn't remember.
Can we change his plea to a no contest, Mr. Fleming?
No objection to that, Judge.
All right, so Mr. Jeffords, because of your lack of memory, would you like to enter a no contest plea and have Ms. Van Dusen place on the record what happened that day?
Yes.
Okay. Ms. Van Dusen, would you like to place a factual basis on the record?
Yes, Your Honor. Give me 2 seconds.
None.
Okay, on August 25th, 2021, Mr. Jeffords was on Frank Street in South Center in Lenawee County, city of Adrian. And a vehicle that was driving by Mr. Summer or Mr. Jeffords picked the statute up and threw it at the window of that car for no reason at all. It damaged the window to a vehicle that was not his and owned by complainant.
And the damage to the vehicle was between $200 to $1,000 to repair.
Yes, Your Honor.
Mr. Fleming, anything you'd like to add?
That vehicle was owned by Michael Summer as well, and people are satisfied.
All right, so based on the facts placed on the record and from the information contained in the police report as read by Ms. Van Duzen, the court does find beyond a reasonable doubt that on or about August 25th of 2021 in the city of Adrian in the county of Lenawee, that Mr. Jeffords did throw a statue at a vehicle belonging to an individual with the initials of MS, damaging said vehicle's windshield, and the amount of destruction was between $200 to $1,000. Therefore, the court does accept the no contest plea. And then, Mr. Jeffords, I will use that for the basis of accepting your violation of probation plea as well. All right?
Yes, Your Honor. Thank you. Yes.
Now, before we had to chase you around. I don't want to have to chase you around again, okay?
I will make myself available, Your Honor.
All right, and then you need to stay in contact with Ms. Van Duzen also because she'll review your reports with you at some point, okay?
Yes.
All right, so we'll see you back here April 6th at 8:15 in the morning. That can be Zoom or if you'd like, Mr. Jeffords, or in person. So I know that you may not have a phone, so you're more than welcome to show up here in person as well, okay?
Thank you. Yes, in person.
All right, we'll see you then, Mr. Jeffords. You have a good day.
Thank you.
Judge, just to make sure there was no bond on my warrant, but you're changing that to PR, correct?
Yes.
Just for the record purposes. All right, thank you.
Yeah, so Ms. Adams, that'll be a PR bond on both of us. All right. You're all set, Mr. Jeffords.
Thank you. Have a great day.
Thank you. You too. All right, Ms. Van Duzen, I have